We're live.
All right, thank you. It is Friday, April 7th, and we are starting H288, and we have Tucker Anderson, Ledge Counsel, to give us a walkthrough.
All right, good morning, Tucker Anderson, Legislative Counsel. H288, for those looking for it, is on the committee's webpage. I'm not going to share a screen this morning because I'm decidedly analog in how I do my job. So I'll be working from the as passed by the House version, what is referred to as the unofficial version. It has none of the redlining in it, just the text of what passed the House. Some background on this bill. Currently under 7 VSA section 501, the state of Vermont has what the Supreme Court of Vermont has referred to as a strict liability standard for dram shop liability. Under current law, what that means is that anyone in the chain of service who has furnished in whole or in part, furnished alcohol that caused in whole or in part the intoxication of a person who injures a person can be liable for the injuries that are caused. All right, we'll start walking through the bill. What the bill does is shift part of that strict liability standard to a negligence standard, eliminate some of the parties from the chain of liability, and in the future require that licensees in the state acquire liquor liability insurance. Section 1 amends 7 VSA section 501. First, in subsection A, you see that the list of persons who have standing to bring a suit is struck. However, all of that language is moved to a definition at the end so that we can just use a term instead of listing all the individuals. And that term is going to be an injured person. So this subsection A will now state that an injured person may bring an action in the person's own name pursuant to this subsection. In each one of the subdivisions that follows, we break apart where strict liability is going to stay in place and where the negligence standard is being brought into this statute.
Tucker, just for the committee and folks watching, can you describe strict liability? Can you also just define negligence for us? Or that's
Sure.
please.
So I'll start with negligence. I have failed to outline how negligence claims are brought almost every time that question's been asked in committee. So I was prepared for it today. Negligence under the common law has four essential elements that a claimant has to demonstrate. First, that the person causing the injury had a duty of care to the injured party. Second, that and I'll just refer to it as defendant, the defendant breached whatever that duty of care is. It could be ordinary duty of care, it could be some sort of professional duty of care, if you're dealing with something like medical malpractice. But you have a breach of whatever that duty is. Then you have injury, right? Some sort of damage that was caused. That's the third element. And finally, they have to demonstrate causation, which is broken depending on the type of suit that you're bringing. Could be proximate damage or direct causation. Great. You've all just passed torts. You can take the bar now.
You're ready, Nutter?
What strict liability establishes is separate from negligence if the defendant has violated the terms of the statute. You have what's known as per se or statutory responsibility there, right? You violate the terms of the statute. That is what the plaintiff brings to the court. This defendant did not comply with the statutory duty. That's where the breach happened. I was injured, therefore they are liable.
And all you have to do for strict liability is prove the facts of what happened, right?
Yes.
Essentially.
Yeah. And that it was out of conformance with whatever the statutory requirements were.
Yeah.
In House Judiciary, some of the members of that committee were vocal that the statute as it was written actually reflected a lot of negligence in the strict liability standards that are established in 7 BSA 501, and that there was some confusion there. But there are 2 Supreme Court cases from the late 80s and mid 90s that say expressly that the statute establishes strict liability. So that's where we were at.
Awesome.
Okay. Subdivision 1, this is where strict liability is going to be maintained. This is the unlawful sale of alcoholic beverages. An injured person shall have a right of action against any licensee, that's a term that will be defined later, who caused in whole or in part the intoxication of the intoxicated person by selling or furnishing alcoholic beverages, and there are going to be 2 here, either to a minor, as defined in 7 BSA section 2, or to a person after legal serving hours. There are statutory standards for both of those. 21 is the drinking age, and there are legal serving hours established in Title VII for all of the licensees. All right, and I will note that the furnishing has been interpreted by the Supreme Court to denote control of the alcoholic beverage that is being served. Moving on to page 2, subdivision 2 is going to establish the standards for negligent service. As we move through these negligence pieces, I'll note that this language was taken almost directly from what's known as the Model Act, which is used almost entirely in Maine, New Hampshire, and Rhode Island. And it was the standard language that the House Committee wanted to use for purposes of defining negligence here. An injured person may bring an action against any licensee who negligently furnishes alcoholic beverages, so immediately establishing that this is a negligence standard, to a person apparently under the influence of alcohol. That is a term that is also defined at the end of this section, apparently, or who it would be reasonable to expect would be under the influence of alcohol as a result of the amount of alcoholic beverages served to that person. So as you are serving an individual, if it is reasonable to expect they're becoming intoxicated based on the volume of beverages you're serving them, that can establish the basis for negligence here.
Quick question. So, and then Tanya, apparently under the influence of alcohol, is that half a drink? Or, I mean, does that word apparently make it so, does that imply that the person is impaired, or is it, because I mean, if you have 1 drink, you're technically under the influence, not necessarily impaired.
So apparently under the influence of alcohol is a defined term in this section. Okay. Under current law. This new standard doesn't change that. The definition, apparently under the influence of alcohol, means a state of intoxication accompanied by a perceptible act or series of actions that present signs of intoxication.
Where was that located again?
It's in subsection H.
Oh, thanks.
Page 4.
Yes.
Thank you. And then
That actually answered my question.
Moving back to page 2, subdivision 3, for purposes of the negligence standard that was just established, subdivision 3 establishes the prudent person standard here. It says that a licensee's conduct is negligent if the licensee knows, or if a reasonable and prudent person in similar circumstances would know that the individual being served is intoxicated.
Is this a different way of saying reasonably should have known?
Yes, and it is a well-developed term of art associated with negligence standards.
Okay.
The prudent person is this imaginary person who is essentially, we'll boil it down to careful. It is your ordinarily careful person in similar circumstances. And that clause gets at, under common law negligence, You either know, or if we use this imaginary person in the same circumstances, you should have known.
Okay,
You have constructive knowledge based on the circumstances.
but from a legal standard, it's sort of similar to the reasonably should have known standard.
It is similar.
Okay, thank you.
And I did bring this whole sheet in case there were a lot of questions about the prudent person, this imaginary figure that we have, who's ordinarily careful. It meets that perfect median of carefulness.
Not too careful.
Not too careful, right? Subdivision 4, this is going to set aside the assumption that a server knows of an individual's intoxication that happened off premises. So a licensee is not chargeable with knowledge of an individual's off-premises consumption of alcoholic beverages unless the individual's appearance and behavior or other facts known to the licensee would put a reasonable and prudent person on notice of the individual's consumption of alcoholic beverages. So the server is not chargeable with knowing that the individual was consuming alcoholic beverages off premises unless it meets that reasonable and prudent person standard of constructive knowledge.
So they don't have to have a crystal ball, but they do have to be aware of the fact that this person is clearly intoxicated.
Right, and you will likely hear if the department is going to testify, Department of Liquor and Lottery, about licensee education in this area.
Is this just put in here for the legalese stuff here, Tucker, whatever else? I'm just thinking of a scenario where I'm the bartender, you walk in, no one else is in the bar. I gave you a drink, turns around, something happens to you, someone sues, where's your witnesses? But when you use the terminology that you've used here, should have, where was it? Unless the individual's appearance and behavior, that just a feel good insertion in this, because there's only two of us sitting here.
Well, the appearance and behavior is built throughout this statute. I mean, when we talked about apparently under the influence of alcohol, it talks about perceptible acts that would indicate intoxication.
So the bartender could be the reasonable and prudent individual in this particular situation.
Yes,
Yeah, okay.
if the individual's appearance and behavior did not indicate intoxication, you can't be charged with that person's off-premises consumption of alcohol.
But if the person is stumbling around, tripping over it, like,
Right. And
then you could.
getting back to where your question started, I think you're pointing to an exceedingly challenging part of being an attorney who either represents plaintiffs or defendants in this area, which is you might have a dearth of evidence. You know, you might not have anyone besides the server and the intoxicated person to gather evidence from. But there are cameras everywhere now, so.
Well, we can only hope, huh?
I think there's a couple in the room right now. All right. Subsection B, this subsection is not changed outside of some of the defined terms that are shifted over, such as intoxicated person and injured person. This states that upon the death of either party to an action, the action survives and can be carried out. Subsection C is repealed, and I spoke earlier about how under current law, there's this chain of liability, and you can sue all of the servers in the line of service who furnished or sold alcohol. Subsection C also included the landlord who owns the premises where the alcoholic beverages are being served. That's repealed.
What was the rationale behind removing that?
I can't speak to the policy decisions of legislators or legislative committees. The discussion in House Judiciary was around having too onerous of a standard or having too many people in the chain of liability that have no direct connection to, or little direct connection to, the service of the alcoholic beverages.
Thank you.
And I'm sure you'll hear testimony again from the department and others about some of the requirements for actually attaining your license. And if you have a landlord, you have to provide evidence of the lease. And many landlords do require liquor liability insurance if they're going to rent a space. And because of the increasing costs in the market, that becomes very expensive if, for example, a landlord asks for sky-high coverage to make sure that they're not going to be liable under the statute.
Okay.
Indemnity. Indemnity can be expensive. All right. Moving along into section H, the definitions. Usually these come first. The definition of injured person, spouse, child, guardian, employer, or other person that was in existing law. Here's something new, other than the intoxicated person. House Judiciary wanted to make sure that the intoxicated person who causes the injuries can't also bring a claim under the Dram Shop Liability Act.
What do you, can you expand on that a little bit?
There was some hesitation in the committee around, all right, under some theories in common law negligence, someone who contributes to the injury cannot also be a claimant in the chain of liability, right? So they wanted to build that directly into the statute to make sure that the intoxicated person who has caused the injury can't sue the licensee who sold them the alcoholic beverages. So in narrative form, the drunk driver who causes some sort of injury can't then sue the bar that sold them the alcoholic beverages, at least under this section of law.
Thanks.
Could you just mentioned under the Dram law theory, what is that, Tucker?
That's the statute. Yeah,
The
sorry.
Dram law? That's the name of the
Yes, they're
statute?
dram shops, and this is another fumble I made. I made it first in House Government Operations. A dram refers to, it's an old timey term for a measurement for an alcoholic beverage, a single dram, and it comes from the term drachma, 1 coin. So there you go.
That's as clear as mud. Thank you.
Yeah,
Yeah,
dram shops are what those who sold alcoholic beverages were called. Your shops where you can buy liquor were dram shops.
Thank you.
I have a question. I think it falls into the category of contributory negligence. I mean, if you have a bartender who is breaking the rules, let's say the bartender's getting drunk themselves and just giving out drinks, and then somebody leaves, they crash, that bartender who was not acting to a standard of care that any other bartender would be acting to, are they still indemnified from any liability?
Yeah, are you asking whether the licensee, like the owner of the establishment, is indemnified against the actions of an employee
The bartender,
because of their intoxication?
yeah, or yeah, let's just,
I don't think that the server's state of mind is going to indemnify them from liability.
Okay.
However, you might be able to get some personal injury attorneys to tell you whether that's the case.
thanks.
In a moment, when we get to subdivision 4 for licensee, you'll see that the licensee ultimately is going to be responsible for the actions of employees.
Thank you.
Okay, so we listed the people who will have standing. What can they have as part of their claim? Well, if they are injured in person, property, or means of support by an intoxicated person, or in the consequence of the intoxication of any person. That last clause, or means of support, is the broadest basis for bringing a claim here and showing that you have an injury. And there are quite a few Supreme Court cases that have taken a look at what it means to be injured in means of support. You can imagine that if your parent, guardian, spouse, whomever dies as a result of injuries or is unable to work in the future because of injuries caused by an intoxicated person, you have standing to bring a suit against the licensee and say, I was injured in means of support. And the Supreme Court has said that this extends to not yet born individuals who lose a parent while they're in utero because of injury from an intoxicated person.
Would this extend to not yet born individuals who themselves sustain injury? Because
I do not know the answer to that. Intoxicated person, any individual who caused injury to a person's property, or a person's means of support. That was used to replace the term defendant as it was used here. There were a couple different terms used throughout the statute for the defendant. Licensee means the holder of a first, third, or fourth class license under this title, and their employees who sell or furnish alcohol to an intoxicated person. And in case you have never spent any time in Title VII, the first, third, and fourth class licenses. First class on premises locations, bars and restaurants that serve beer, wine, and ready to drink spirits beverages. Third class licenses, your bars and restaurants that have a license to sell spirits and fortified wines, which they get from the Department of Liquor and Lottery. Fourth class licenses on premises serving locations located on the contiguous property of a manufacturing location. So those would be your serving rooms at a distillery, brewery, winery, etc. Cidery, I'll throw cidery in there. Cider has its own definition now.
oh, yes, it does.
Section 2. So this is amending the same section of law.
So I have a question about 5, and I recognize it's in the previous section, and I recognize it's not a change, but a social host, would that be like if people are at my house?
Yes, and the social host subsection wasn't changed, so it's not included in the bill. But social hosts are set aside from other servers and furnishers of alcoholic beverages. There's a carve out for them where strict liability doesn't apply.
So it does not apply.
Right, and I can send you some cases on how social hosts are treated differently under Vermont's liquor liability statute.
That would be great. Thank
Yeah.
you.
So the same section of law is amended in section 2, and that's a spoiler that later on there will be multiple effective dates. So this is going to add a new subsection I in 2024. Subsection I is going to require liquor liability insurance for all first, third, and fourth class licensees, which are the licensees covered by this statute. DLL, in consultation with the Department of Financial Regulation, shall adopt rules governing minimum policy requirements, including coverage amounts for this liability insurance. And prior to the issuance of any of the licenses covered by the statute, DLL is going to require the licensee or applicant to carry insurance that meets the minimum standards that are adopted by the department. So the short way of saying this, DLL is going to adopt rules for minimum coverage amounts and requirements for liquor liability insurance, and those first, third, and fourth class licensees are going to have to carry insurance that meets those minimum standards.
And will that on each renewal be verified by DLL?
Yes.
I heard that too.
Section 3 touches on this issue, but it's slightly different. This is going to be notice to landlords of licensee violations. This is going to add the requirement that the department ensure that owners of a premises that are leased by a licensee are notified of licensee violations of alcoholic beverages laws. So landlord liability was stripped out of the liquor liability statute, and they added a provision here that is going to require the department, anytime there's a licensee violation, to notify the landlord. So now the landlord is going to have actual notice that there are alcoholic beverage violations happening on their premises. Section 4, the staggered effective dates, sections 1 and 3. So that's the negligence changes to the liquor liability statute. And the notice to landlords are going to take effect this July 1st. And then that insurance requirement, including the rules adopted by DLL, takes effect next July 1st, July 1st, 2024.
Any other questions?
I had a question. I apologize for coming in late. Maybe it was referred to earlier, but we have had an issue in various areas with liability insurance and potential bars or even current bars not able to get or continue their liability insurance. I had assumed, I guess, that this bill was somehow aimed at that, but
That's what I've heard as well. And I think
Okay.
maybe we'll hear more of that from the chamber and maybe the LL.
okay.
Unless-
So not something that they worked on in the House, but that we could add.
They did work on it. This bill is a product of addressing that exact situation.
Can you
And
explain how that is the case?
sure. So from what I understand, the rates for liquor liability coverage in Vermont are very high right now for two reasons. The first, Vermont can't necessarily control, which is some fluctuation in the reinsurance market, which is causing insurance rates to increase broadly. The second, Vermont can control, which is that Vermont is one of two states that has a strict liability standard for liquor liability. And there's some sort of grading system that the insurance market uses to say, this is a friendly state, this is not a friendly state.
I see.
And Vermont is categorized as the most unfriendly to
So
the
this
insurance
moves us
market.
away from strict liability.
That is the intent of, yes, it does move away from strict liability. And the intent of doing that is to make it more friendly to insurers.
Got it. Thank you.
Thank you. And next up, we have Wendy Knight, Commissioner from DLL.
Hi again. How are you, Senator?
Good.
Mr. Perkins? How are you? I haven't met you. My name is Wendy Knight. I'm the Commissioner of the Department of Liquor and Lottery.
My name is Bob Marsh. I'm from Franklin District.
Okay, great. How are you?
Good, how are you?
Good to see you
Let's
again.
go.
Okay, thanks for inviting me. I will answer any questions you have, but let me just give a quick overview of where I understand where things are and clarify what we require of licensees and what we don't. Is that a good place to start? So generally speaking, we are interested in making sure that we support the hospitality sector. So the department is, and the administration is, this is designed to help support the hospitality sector, the bars and restaurants that are having difficulty getting liquor liability insurance. And the chamber can speak to that. We also did a survey of some licensees to get a sense of the issue. So to your question, Senator, yes, this work that was done in the House and the bill you're looking at was designed to address the challenges that the bars and restaurants are having in terms of securing the liquor liability insurance. And Commissioner Gaffney will talk more about that insurance side of it. We just want to make sure from the department's perspective, since a critical mission of ours is to ensure public safety and to make sure that licensees are in compliance, we just want to make sure that whatever we do, whatever the legislature does, doesn't negatively impact public safety. So those are kind of our lenses, right? As a department, our mission is to, as a control state, we're the sole distributor of distilled spirits. So we have a commerce, we want to sell, but we want to do it responsibly. So we have that dual mission.
Sorry, real quick, can you
Yes,
just define for me what a control state is? I haven't heard that
correct.
before.
Yep. So liquor distribution is handled state by state, right? So the federal government has, the TTB has certain requirements, but the states determine how they're going to distribute and regulate distilled spirits. So controlled state means that the state actually is the one that is purchasing the alcohol from the suppliers. We store it, we deliver it to the 802 Spirits stores. And so we are the sole distributor and the sole seller of distilled spirits. So if you are a bar or a restaurant or a walk-in consumer, the only way you are able to purchase distilled spirits and fortified wines is through our department via the 802 Spirits stores. So the bars and restaurants, just like a walk-in customer, are purchasing their spirits and fortified wines from the department at those stores.
Thank you.
You're welcome. So a couple of points you were asking about training. Right now, the department does not require liquor liability insurance for bars and restaurants. We, of course, require business liability. As it turns out, many of the licensees, as we know, and through our survey, they are acquiring liquor liability insurance, or at least trying to, but it's not a condition at this point from the department. It is a condition that you have liability insurance. It is a condition of licensure that you either show that you own the building, or as Tucker pointed out, then you present the lease. If you are renting the space from a landlord, then you need to show the lease to us. So we have a whole criteria of things that we look for when we're going to license someone or renew their license. One of the conditions is that servers have training. So there is training that the department provides in terms of what intoxication looks like, over serving, what to look for. So as a condition of license, all of the servers in the licensed establishment or sellers need to have a training certification that then they need to be able to present to us if there's one of the investigators goes in or we're trying to renew them. So they all need to be certified. And so when you talk about, and Tucker's talking about prudent and responsible and signs of intoxication, there is training that we require that they know, okay, what are signs of intoxication? So they would reasonably know, if they're trained, that if someone presents and can't walk straight or talk or slurs, there are obvious signs of intoxication.
Senator Bohofsky, yes.
Is
Sorry?
that one standard training, or are there multiple different trainings that have been approved by the department for use for that certification?
So we have all kinds of videos on there, but there is a required training for the servers. And Lieutenant Brandon King, if you is on the line, and he oversees the enforcement and the education. And if you have anything, Brandon, to add to that might be helpful for the committee, that would be great.
Sure. Brandon King, Lieutenant with Vermont Department of Liquor and Lottery. Just to clarify your question for me, ma'am, are you looking for if we have, so the department does offer, as the commissioner said, several different trainings. So the department puts together a specific training that our education manager and education coordinators put out themselves. And then we do have several other training programs. So one is where a licensee could become a certified trainer. So if they had a manager or an owner of that establishment, we train them and then they can train their staff. And then we also have several third-party options where a company comes to us, they present a training program to us that meets all the needs of the state, and we certify that program as eligible within the state of Vermont to be taught to sellers and servers. Does that answer your question?
It does answer my question. I know there's been this rise of you can basically just purchase any certification offline with it. So what I wanted to make sure is you're really vetting the training and you know what people are.
Yes, we create the training program and then we certify that the servers and the licensees are getting the training.
Perfect. And is there some sort of competency test to acquire that certification? To make sure that, I'm trying to think how, just to make sure that people actually have taken up the skills. It's one thing to present a training, it's another thing to be assured that the person actually comprehended it.
Yeah, and it's a certification.
Okay.
So we can get you details,
Okay.
but they have to, there's a quiz, right?
Perfect.
It's not just listening to a 15-minute video.
Perfect, thank you.
We need to
And
go
that
over those.
training is required, that training is also required every 2 years. So if the person remains in the industry, they are constantly getting updates and they are constantly retrained.
Awesome, thank you.
So just a couple of things as I'm looking through the bill. I understood that the Tucker had pointed out that the landlord liability was eliminated. And I think, Senator, you were asking the question of what was the reason for that? And then I see that that says that the department will ensure that the owner, I guess the page 6, section E, we are to ensure that the owner of a premise leased by a licensee is notified. So it's requiring, there's no landlord liability, but it's requiring the department to notify the landlords if a licensee had a violation. And I guess I don't understand if the department is not, if you're eliminating landlord liability, why are we required to notify the licensees of a violation?
You mean the
That-
landlord of the violation?
Correct, yeah. So it's just a question I have in the department we had. Well, why are you requiring the department to notify landlords if the licensee had a violation? So I guess that's for you all to consider or ask House Judiciary or Tucker or somebody. But that just was kind of, it was something we noted in the department.
Well, if you want to stop the behavior, even if there's not landlord liability, it's still, in a sense, creating another set of eyes on the property. Although it is a task that you guys have to complete, which is work from your office.
Right. I'm not objecting to it. It's something that in the department we just
Wondered about. Yeah.
The other is the effective date. And I see that the section 2, which requires the department to ensure as a condition of licensure that the bars and restaurants, it's the first, third, fourth class, so bars and restaurants and manufactured tasting rooms. The effective date is July 1st, 2024. And I wondered, somehow someone had discussion about it, why we've chosen that. I will let you know that what we are doing in the department, so every year, this time is renewal time for our licensees. We have an online licensing portal that we launched in August, and May 1st historically is the sole date by which we renew licenses. Because of the online licensing portal, and in statute a year ago, we have the ability to issue staggered licenses, which is our intention. So we are no longer going to be renewing the thousands of licensees at one point in time every year. We're going to stagger them. We will start that now. So this July 1st, 2024 effective date is problematic for us because if we're going to require as a condition of some of these licenses to get liquor liability insurance, unless you just want to put it off a year, and maybe Commissioner Gaffney or the chamber can speak to why that makes sense, or Tucker, you can.
Senator and then Tucker and then.
So I certainly can't speak for House Judiciary, but there's some rulemaking in that section, is my understanding. And my guess is that date is to give DLL time to do the rule.
With DFR. Okay.
There are two pieces to the July 1st, 2024 effective date that House Judiciary took a look at. The first is they wanted to make sure that insurance rates actually did come down as a result of converting to the negligence standard before every licensee was required to acquire the insurance. They didn't want to put this requirement in place when the rates are as high as they are now. And the other is that they assumed that the department and DFR would need time to monitor the market before adopting the rules. And a note on that is that, this takes effect July 1st, 2024. That's when DLL gets the authority, and the rulemaking process takes 6 to 8 months. So the July 1st date should line up generally with, I think, when the bulk of the license renewals come in, even staggered. time period, right? Like early spring.
Yes, yeah, so so the renewal is usually May 1st, 2024. Again, we're gonna start our staggered license this year, so between now and May 1st, we will have a staggered license renewal. So when I think about the next round of, it just means we can't require this until July 2024. It's fine. I think that's fine. I'm just pointing it out that we're not doing the annual renewals. So,
But over the course of, like, between July 2024 and
Mhm.
July of 2025, eventually everyone will get
Correct.
captured kind of.
correct, correct. And that was the idea behind the renewal, as we want to put it onto the fiscal, right? It should align with July to July. So within that July fiscal year, then we can break it out every 3 months. There's a set of licensees that get renewed. Do you have anything else I can help you with or answer?
So
No.
are you good with the effective dates after the discussion?
I
or-
am.
Okay.
That's helpful, Tucker. Thank you. As always, you're very helpful.
Any other questions?
Okay,
Thank you.
thank you so much.
And next we have Tom. The Vermont Association for Justice.
Good morning, everyone. My name is Tom Scherer. I'm an attorney in Burlington. I'm St. John's originally. Been practicing in Vermont for almost 40 years, which is a mystery to me how that 40 years has gone by so quickly. What's interesting about that, though, is my legal career actually mirrors the statute that you're about to change or thinking about changing. Back in the mid 80s, there was a lot of issues around drunk driving. Mothers Against Drunk Driving were a big force, and the legislature was looking to address this issue. And from that time period came this legislation in Vermont. And basically that legislation hasn't changed very much in the last 40 years. Why we're here today is a segment, a relatively small segment of the hospitality industry is experiencing very large increases. And they have gotten the ears of different legislatures saying, we have to change the statute because it's driving up our rates. Couple of things. One, this is a national problem, not a Vermont problem. It's a national problem. Rates have gone up. What's happened in Vermont in terms of what's happened in cases, courtrooms, verdicts, has nothing to do with the rate increase. I've been in all the prior hearings. There's been people from the insurance industry coming and testifying. What one of the other witnesses did say is correct is Vermont is viewed as a not favorable state from an insurance standpoint. And what's that based on? It's not based upon the cases. It's not based upon the verdicts. It's based upon a perception by an insurance entity that grades states. And they view Vermont as a hostile state because of the description of the existing statute as a strict liability statute. So for that reason alone, Vermont gets kind of a failing grade with one other state. Again, nothing to do with what's happened on the ground. Let's talk about what's happened on the ground. Since the statute has passed, a lot of wonderful things have happened to minimize the number of people who are injured, maimed, and killed by people who are overserved at bars. So what's happened? Bars, the state has stepped up with the training that you've heard. Bars has stepped up to make sure their people are properly trained. And so the actual incidence of people being injured from being overserved at bars is really minimal. I'm here in part because I think I probably brought more dram shop action. And to your question, Senator, dram shop and liquor liability, that's the same issue we're talking about. In my 40 years career, 600 cases, and I've been involved with 3 cases. I sent when I started testifying here about a month ago, I sent a message out to our membership. Does anybody have a dram shop case, or can anyone remember a dram shop case in the last 5 years? Nobody. I spoke to two mediators who have mediated over, between the two of them, 10,000 cases. They can't remember a dram shop. So we are turning ourselves inside out on a statute that has been very effective, not abused by the attorneys, not abused by Vermont juries. We're turning ourselves inside out to try and become more favorable to an insurance industry that views us as unfavorable because we quote have strict liability statutes. So we are not unsympathetic to, again, it's a small portion of the bars. It's particularly bars who are serving past midnight.
Mhm.
Those are the ones who are really seeing their rates increase. One of the other things too, that's a huge thing. This is what's called a hard insurance market. And a hard insurance market means when premiums go up and the availability of insurance goes down. This happens on a cyclical basis in a lot of different areas. We had this very issue with medical malpractice insurance about a decade ago. And a lot of that is related to what's happening in the stock market. The insurance companies put their, make money from a good stock market. When the market's down, they increase the premiums. Well, just look what's going on right now. This is all what's happened in the last couple of years. It's got nothing to do with what happens in Vermont. And I must say, I was surprised when the legislative aide said about the why there's a delay in making the requirement for insurance 1 year related to if the rates are going to go down. Nobody thinks, I believe, really thinks the rates are going to go down in a year. As a matter of fact, when some of the insurance people were asked if we make these changes, are the rates going to go down? They go, well, it'll help. They're not committing to anything. So while we as the trial lawyers representing people who have injured have been willing to work with the legislature on changing some of the language so that it doesn't appear that Vermont is this place where you just, if someone serves somebody a beer and then they go out and kill somebody, you get sued. We're happy to work to change that. One of the things that I found out, and probably was done here, was 2 years ago. I had a young woman, a single mother, early 20s, goes to a bar with a group of friends, obviously drunken patron, gets in their face, and she takes a mug and throws it in the woman's face, and she loses her eye. This was with Reuben James, downtown Burlington. We bring the lawsuit because for a host of reasons, all the standards were all met. And we find out Reuben James doesn't have liquor liability insurance. They have liability insurance, general liability insurance, but that doesn't cover liquor liability. So we get a $750,000 default verdict against Reuben James, but there's no insurance. So what just became very clear to me now is the woman who was just testifying just said, well, we require liability insurance. Well, that does absolutely nothing for liquor-related problems. That is excluded from those general liability policies. So they're making a requirement that's going to help if someone slips and falls or something, or a table collapses. It does absolutely nothing for anyone injured because of over-serving. So one of the things that we think is extremely important for everybody's sake is a requirement that if you're going to serve alcohol, you have liquor liability insurance. And we think that, it's not a mystery what the levels are. It's normally 100,000, 250, 500, $1 million. Massachusetts requires liquor liability insurance at the amount of 250,000 for every licensee. So we can address that when we go through the bill, but that's just another issue there. What else? Where to kind of start?
If I might,
Yeah.
just to clarify, I think you just mentioned that you represent trial lawyers?
Yeah.
Okay, and Vermont Association for Justice is one of several, or the association?
So there are a number of different associations in Vermont.
Okay.
So I'm a practicing attorney. I don't work for the organization. So we represent the plaintiffs, the people who are injured.
Mhm.
There are defense attorneys who represent the insurance companies, but we just
No,
represent,
I'm just talking about who are your members?
oh, it's primarily plaintiffs, the bar.
Okay,
People who bring medical malpractice lawsuits.
okay, great.
Yeah.
And then my second question would be, did you testify, or your organization testify on this in the House?
Yes, I did.
And so is this partly your work product?
Well, we don't agree with a number of the things, but like I said, we're willing to work to try and help if we can, but we just don't, we think it's kind of crazy to take a bill that's been extremely successful and change it because of a episodic change in the
Well,
insurance market.
And I get what you're saying, which is that you don't agree with the impetus for why the bill is changing.
Right.
I hear that. I'm wondering, do you find the changes destructive in some way, or do they?
Yeah. Well, so a couple of things, that this is a strict the present statute, the strict liability statute is really a misnomer. It really isn't. You have to prove that someone was intoxicated.
Mhm.
So we're actually taking out, and we're okay with this, to make it clear that it really is a negligent standard, because that's what it really is anyway. So some of that language is fine. What we completely disagree with is, why would you take out landlord liability? They're not the ones complaining. They're not complaining at all. Their general liability policy is still there. And I think to you, Senator, I noticed you made some reaction at one point when it was brought up about landlords. I brought landlords in one case of the three that I brought. And the reason I brought in the landlord was everybody knew in the town knew that this bar was over-serving people. There are fights, there are accidents from the bar. Everybody knew. And the landlord should have stepped in and said, hey, clean up your act. And so by taking the landlord out, as you said earlier, now they don't have any real responsibility to make sure that the bar is behaving properly. So I just don't understand. It just doesn't make any sense to me why the landlord was taken out of the statute when their policies are not going up because of this, because it's just a general liability policy.
I do just want to just make a note for time. I do know we have two more witnesses, and I just want to be considerate of
Sure.
everybody's time and also make sure everybody gets a chance to get some time to speak. So
One of the things, the other thing I want to make clear is, again, things are destructive. One of the things that's changed is in the present statute, a person could sue the bar, the bartender, the waitress, and the landlord. So all that's left now is the business, the licensee. So I've talked about the landlord. The issue about taking out, and I understand it doesn't change things that much, but as we all know, if you've been in a bar or a restaurant, there are servers who will, as long as you're tipping someone good, they will continue to serve you alcohol, even if you're drinking more than you should. If they're personally liable, that's an incentive not to go along those lines. So that's something that we're taking out of this bill as well. So that just to your question about that. Just looking at the bill quickly, to be very specific, there is still going to be the strict liability standard about the people who's a minor and serving after hours. I think that's still going to be a red flag with the insurance people who think that's still a problem. Changing, as I said, changing it to the negligence standard, we don't have a problem with. The section about landlord liability, obviously, we think should be put back in and not taken out. And over on 501 about the liquor liability insurance required, we think that's really important. And we also think that just like with underinsured insurance in Vermont, how the statute requires everyone to have minimum insurance, it's in the statute. We don't think there's any reason why it shouldn't be placed in here, right in the section, and not necessarily turn that over to another administrative agency. Just put in a minimum of 250,000 right in the statute. So that's basically what I had. I'm here to answer any other questions you might have.
Do you have any data or statistics that compares a state like Vermont that has strict liability, and then as it relates to dram shop law cases compared to other states that have negligence in their statute for their dram shop laws, in their cases for dram shop lawsuits?
So there are very few cases in Vermont. The insurance people will tell you that Vermont's cases are so small, they're statistically irrelevant. So, there's really nothing to compare. I mean, it's not like Vermont is a place where it's easy to sue a bar because we have strict liability. Number one, very, very few cases are brought. I'm talking one a year, if that. So it's just a perception. It's not reality with what's happening on the ground in terms of what's happening in Vermont courtrooms. It's just very, very, very few cases. And in the Judiciary Committee, the different insurance representatives were asked, well, what are the statistics in Vermont? And they wouldn't answer the question, even though they do know how much they've collected for premiums and how much has been paid out. They do know that. So what happens here has no bearing on what the rate is in Vermont. And I doubt very much there'll be much of a change, certainly not in a year. And there's nothing that I was aware of that connected the requirement for mandatory insurance to a drop in the premiums. I'm certainly hope, because it appears that this is kind of like a loophole that has inadvertently been converted, because the previous woman who testified indicated that we do require liability insurance, but that really doesn't address the issue. So they should require liquor liability insurance regardless of that.
And this bill will do that, though, just beginning July 1st, 2024.
Yeah, section 2.
That's what I thought. I just wanted to make sure that I was reading it correctly.
Right, but there was a question about why it was delayed that long. Was we want to make sure that the premiums are going to go down? And I don't see that there's any contingency, because I don't think the premiums are going to go down in 1 year anyways. And I still hope that provision is not impacted by that.
Senator Norris, saw your hand up.
Yeah, I'll just, in your opinion, you state that there's no dram suits, there's one
1 year.
1 year, in fact. So what we're hearing is the cost is going up. And if there's no suits that are taking place, and I know you want to put everybody under this one blanket here, the bartenders and what you said, and whoever else, for what purpose, I have no idea. But so in your opinion, if in fact the rates are going up, why is that?
They're first of all, they're going up because of this hard market. They're going up not because of what's happening in Vermont, because there's so few cases and so few verdicts and settlements. They're going up because the insurance company's profits are down because the stock market's down, so they increase premiums. It's a problem that's happening nationally. It has got nothing to do with what's happening in Vermont. But if the insurance people think we're a strict liability state when we're really not, and we can change this language to help so that in that grading system, we're not at the bottom, that we move up, that's fine with us, because it really doesn't change the burden of proof that we actually have in trials anyways.
Senator,
To that point, so, and I'm just trying to figure out the extent of your organization's support or not support of the bill. So it does require liquor liability insurance, which it seems you favor.
Good thing, I think everyone
Yeah.
would favor that.
And then, as you say, it makes some changes in the law that might affect the perception of the insurance companies and the state. So I'm having a harder time trying to figure out what, seems like you should be in strong support of the bill, but the feeling I'm getting from you is that you don't want changes in the statute.
Well, like anything, sometimes there's some trade-offs, and we think having the mandatory liquor liability insurance is a huge thing.
Yeah.
And seeing how we basically are proving negligence anyways, if you change this and that's going to help lower the rates, we're all for that.
Okay, so
Those two changes.
you're in support of the bill.
Well, I'm in support of some of the provisions of the bill.
I'm just trying to figure out
Yeah.
what you don't support and why, and why, because it's I keep missing, it seems like you have some real opposition, but I'm having a hard time figuring out where it lies.
So, the kind of general opposition is, we don't think this is gonna make a big difference
Okay,
overall. And what has been working in terms of people who have been injured, and bear in mind, when people are injured, the two other cases are deaths, 18-year-old and a 22-year-old, and a badly mangled person, the cases I've had.
Mhm.
So when there are injuries, they're normally catastrophic injuries. So it's good to have a remedy for those things, for those people who are injured. The other thing that's good about this is, in the case I've had, I'm paying back Medicaid for the $100,000 that they put out from settlements. So that's another kind of byproduct why it's good to have insurance to be able to repay Medicaid from these type of horrific
Yeah.
injuries occur.
but that seems like it's supportive.
The mandatory insurance.
Yes. So, yeah, I suppose it doesn't matter. I hear you saying on the one hand, you want to support changes. You don't think that changes that affect the perception will be any harm.
Right.
But then you're saying you only support parts of the bill. So I'm wondering, what, it seems like there are some wording changes that you're okay with, and you love the new insurance component. Is there a piece here that you're wanting to register opposition?
Sure, the main one was dropping the liability limit. That's the
Okay.
thing I just think doesn't make any sense.
Okay, so that's
That's the main thing we're against.
Thank you. We're running tight on time, and I want to make sure that Mrs. Spear has the opportunity.
Thank you very
to-
much.
So, yeah, thank
I'm
you for
available
coming.
for any questions too.
Okay.
Thank you. So Amy, we do have another bill at 10:15. Is 10 minutes enough, or?
I
would you
can
like-
do my best to at least set the foundational information, if that makes sense.
That sounds good. And then we can have you come back when we pick the bill up again, and then Commissioner Gaffney will have to reschedule, unfortunately.
Perfect. So for the record, Amy Spear, I'm the Vice President of Tourism with the Vermont Chamber. I am also with Vermont Independent Restaurants. They're a strong working partner of ours, so we appreciate the opportunity to weigh in on this. To be brief here, I'm going to try to say the 50,000-foot view to leave time for questions. What started as an issue in 2021 for us to try to understand why is liquor liability so expensive in Vermont compared to other states has very quickly accelerated, and we're now realizing it's because it's rooted in our state statutes. As mentioned by previous witnesses, because of market conditions, we have seen those costs accelerate. But I think one important thing to note here is that, yes, while many businesses are required to have the general commercial liability, liquor liability insurance exists because of dram shop laws. They are a direct reaction to dram shop laws. And what a lot of people have been talking about here today is Vermont's ranking as a 10, which is an ISO number. Those numbers are based on your dram shop laws and relevant case law. And so to give you an idea, Vermont and Alabama rank as a 10. Not often is Vermont compared to Alabama, just to put that out there. When we're looking at ISO grades for neighboring states, we have Maine at a 4, Connecticut at a 5, Rhode Island at a 6, and New Hampshire at a 7. And Vermont is not the only state that's looking at its liquor liability laws at the moment. There are many other states around the country that are. I've heard from colleagues that are other restaurant associations that it's generally a 6 for an ISO rating, that's the tipping point. And again, I think the core point to make here is that it's, the ISO rating, which determines or largely helps to determine insurance rates, it's based on your dram shop laws and relevant case law. To that point, we've had businesses in our membership that have been told that they're trying to secure their liquor liability for this year. If you were just over the border in New Hampshire, I would be happy to write you. Because you are in Vermont, I will not write insurance for you. And that is because of our state statutes. To give an idea of the levels that are being impacted with the businesses right now. So if you are 35% of your gross sales are attributed to alcohol, it's relatively easy for you to secure liquor liability insurance. And right now, it's not even just the cost of liquor liability insurance, even the ability to secure liquor liability insurance. So those businesses that are about that 35% level, they're able to not only get liquor liability insurance easily, they're also able to do it on the admitted market. And I will let Commissioner Gaffney take additional, he'll be able to give you additional details on that, but essentially the admitted market is regulated by the state, which means that it has a safety net to it, not only for the businesses, but for those that are making for the insurance market as well. So when you're going to about 50% attributed to gross sales, that's when it starts to get difficult to obtain liquor liability insurance. I think you'll hear from some businesses next week and their story when they were trying to close on their new business, what happened when they were trying to procure their liquor liability insurance. They could do it, but it's extremely expensive and many times over more expensive than that of the previous owner. And where we're at this critical tipping point right now is for businesses that have 70% or more of their gross sales attributed to alcohol. So that would be your nightclubs, music venues, your bars, your standard place where you're going to go out to get a drink. But it also has to do with those that provide like wedding bar catering service, and then also think of your social clubs, like your Lions clubs, the Canadian club that's in Barrie, they're also not able to get their liquor liability insurance right now. So it's not even a matter of expense, it's a matter of being able to get it, which we see as a big problem, because not only do businesses see that as a prudent business practice to have liquor liability insurance, it's also a public safety issue. And so being able to have the market react to our state statutes so that it's accessible for businesses to purchase liquor liability is really the core of what we're getting at. So trying to be brief, I'll pause there and I'll take any questions you have.
I have a quick one. So Amy, thank you. Mr. Shearer had testified that there's probably one, was it drain in the past 20 years, and been any, from what I can gather, there's maybe one a year as far as liquor law violations. And if this law has been on the books since like the 80s when MAD came to fruition, so on and so forth, in your opinion, so why now is this an issue with the insurance companies?
Yeah, because liquor liability insurance is directly tied to our state statutes. When Vermont has an unfriendly, we call it a blanket unfriendly state statute for liquor liability insurance. And then you have a hardening insurance market, which means either less admitted carriers or higher costs. That's where we're getting to this nexus of this critical tipping point, because it's all tied back to our state statutes and relevant case law. So that's
They've
really
been there for a number of years.
Yeah.
So is it actions that are taking place in other states? Now they're looking at Vermont as a 10. Is that the reason why it's going up?
So Vermont has always been a 10. So we've always been a 10, but it's because of changes in the insurance market that it's now either becoming very expensive or impossible to procure insurance. So it's this odd intersection of law and insurance being completely intertwined, and one needs to change for the other to correct itself.
Okay, just a quick follow-up. Could you, and maybe you can't, could you give us an example of quite expensive from 35% of alcohol to 70%? What are we looking at for cost here?
Yeah, so to give you, I'm gonna try to think of I'm gonna pull up an exact number for you. So there is a business that's looking at this past year, they paid $16,700, and this is in the written testimony that was submitted on behalf of an insurance agent that's on the committee page today. They went from $16,000 up to $34,000 in 1 year for a quote for insurance. So not only is it expensive to get it in the first place, it's also dramatically rising.
Okay, thank you.
Thank you.
I was just gonna point out, I think we tend to think of the market as this organic force that's out there like a storm, and it comes and it goes. And, I'm thinking about an insurance company. Is it overstating the point or putting too fine a point on it to say that they're pressuring states to change their laws so that they will pay out less money overall?
I would say not necessarily the case. It's primarily there's a rating organization called Verisk that provides this ISO rate, which is a recommended, so it's part of the actuarial side of insurance to
But
say,
that's always been a 10.
it's always been a 10.
So what's changed is that they're refusing to offer us insurance.
Right, because of our state sanctions.
So they're pressuring us to change it or they won't write us insurance.
It's not even pressure that's coming from the agents. It's really coming from the businesses that say, I want to get insurance. But
No,
to
no,
your
it's-
point, yes.
Yeah. So I'm just saying, we're in some sense at the mercy of a company or companies that are refusing us the liability insurance unless we write statutes that will ultimately produce less statistically in payout for them. So unless we make their bottom line in some sense stronger, they're not gonna write.
I guess that's a very like simplified way to think about it,
That's how I
but
view the
it's
world.
all, it's all nuanced, I would say for sure.
Yeah.
One point that I do want to make just on the
Is it a change underway in Alabama?
I'm unclear on the change in Alabama, if there's anything underway in
Okay.
Alabama.
Because I would imagine they're going through the same thing we are, which is their dram shop owners coming to them and saying, we can't get insurance, we need to rewrite our laws. I just, not that it should stop this bill or not that there's anything that the chamber or anybody else is doing here, but just to point out in the system we live in, it's very powerful corporations often that wind up driving what we're doing at the table. So,
One last note I do want to make on the mandatory liquor liability insurance. We have not heard anything negative from our membership regarding mandatory liquor liability insurance. It's just a matter of being able to access it. One thing that I would encourage the committee to consider is when you're looking at the effective date, perhaps instead of an effective date of July 1st, 2024, perhaps set a date that DLL and DFR can come to the legislature with a recommendation. And the reason I say that is to avoid unintended consequences, because not only is it restaurants and bars that are procuring, that are licensees, but it's also small inns and bed and breakfasts as an example. So those that might serve a mimosa with breakfast, or they might have a welcome reception where they're serving their guests a beer. That is the totality of the licensee. So it's more than just restaurants and bars to factor in there. So that's just one aside that I'd like to make as a note there, but I know I'm trying to be really quick and keep you on.
No, that's fine. It was something else.
No, it was, yeah, something else.
Yes.
well, thank you.
Yeah,
Appreciate it.
yeah.
Thank you.
Commissioner Gaffney, we're running pretty short on time and we have several witnesses lined up to start 1 minute ago. Would you be all right with coming in on Friday of next week at the top of the list? Is that all right with you?
Sure. Happy to do that. Happy to make a few quick comments if you'd like.
Yeah, we can take a few quick comments.
Okay. I'll try to be
Actually,
brief. For the record, Kevin Gaffney. Did somebody say something?
nope, we're good.
For the record, Kevin Gaffney, Commissioner, Department of Financial Regulation. Yeah, I know. I just want to level set about the marketplace and a hard market. It's more than pricing. It's capacity. So what capacity means is if companies don't have reinsurance available to them, they have to decide what markets they participate in and what they don't. It's not about dictating will on changing laws. It's recognizing and it is the fact that Vermont's law is very strict. It has strict liability. It doesn't have a negligence standard. Even this bill as written does not maintain a negligence standard throughout. There are those a couple of exceptions. So I'll just say that the direction the committee has gone and the committees have gone is a movement in an area that's consistent with our neighboring jurisdictions. And there's no guarantees of how the market will react, but the market has reacted already. The market has reacted here in terms of limited availability, and I can't assure any pricing change, but my biggest concern is that there's availability first. And then once there's availability, once we have more participants in the market, competition helps with the pricing. But if you don't have participants in the market, it's going to have an impact on pricing. So capacity of the marketplace for the businesses is critical. I really am very appreciative of the survey that the chamber undertook. It was at our urging that they did that. We'd like to digest more of that information to make sure, as we do, we work in collaboration with the Department of Liquor Lottery to develop a rulemaking on the minimum limits requirements. So we do it in a judicious manner. So that's why I do agree with the timeframes. The 7/1/24 change makes sense. Typically, when you have changes to insurance requirements, they happen as an effective date for new and renewal. So those changes will take place between 7/1/24 and 6/30/25 with all the renewals that will happen in that 1 year. And that is the convention and the right approach to give businesses a time to adjust, allow insurance companies to just incorporate those changes in their renewals. So I'll leave it there for now, but I think this issue of trying to satisfy what an advisory service organization sees Vermont as is, while maybe the long-term goal, I think the short-term goal is if these changes are substantive enough, and I would just have the committee look at the exceptions that you do have. It does not line up with our neighboring states. And I'll just say that we're going to be looked at a little differently because there's some holdouts for strict liability. And I think one of the earlier testimony even pointed that out, that a negligence standard throughout would be a more consistent approach. So I know you don't have time. I appreciate you giving me some time. I'm happy to come back next Friday to talk more.
Thank you. That would be great. Sorry to compress your testimony so short, but if you want to come back on Friday next week, we're happy to have you continue testifying.
Sounds great.
Thank you. So let's just